You plan on leaving your kids an inheritance believing that's their separate property. But here's the truth. The moment they deposit that inheritance into a joint bank account, it becomes marital property. That means that the $500,000 or the family home that you pass down to them could be split up in a divorce settlement. In this video, we're going to cover the biggest mistake that people make, the type of trust that will protect your child's inheritance, and the 5 steps to set it all up so that your money stays in your family, does not go to an ex-spouse. Commingling is the biggest mistake that people make, and it makes half of your inheritance vanish. The problem is that your child is likely in a happy marriage, and they're going to take the money that you give them and deposit that inheritance into a joint bank account with their spouse. Or maybe they use that money to pay off the mortgage that they have as a down payment for a property that they live in, or to put money towards an investment property. Now fast forward 5 years and they're going through a divorce. Their divorce attorney is going to argue that that money is marital property because you used it to benefit the marriage. At that point, subject to being split in the divorce settlement, and the judge could order your child to split half of their inheritance with their ex-spouse. Don't let your child's inheritance get split in a divorce settlement. If you want help protecting your assets and the assets are going down to your kids, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team. Okay, let's talk about the separate property lie. You may believe that inheritance is automatically separate property. Now, you're not wrong. Technically, an inheritance is going to start out as a separate property, but that protection is fragile. It only exists if you perfectly maintain separation of that inheritance from the marital property. That means no joint bank accounts, no mixed using, and you cannot use it for joint benefits. The burden of proof to show that that money was inheritance money and that your child kept it perfectly separate is going to be on your child. And so when they're going through that divorce settlement, the ex-spouse will not have to prove that your child did not use inheritance money or did use inheritance money. It's going to be on your child to prove that they did not use it and that they kept it perfectly separate. So let's talk about how to protect the inheritance from your child's future divorces. Now, if you give them that money, it's a gamble, but you can put it inside of a trust that will give it protection from your child's divorces. So instead of leaving your inheritance to your child in their personal name, you're going to be leaving the assets inside of the trust, and that will keep it fully separated from your child. That way it's not able to be separated in a divorce settlement. And so with that, the trust legally owns those assets. Your child does not own those assets, but they can benefit from those assets by taking distributions for things like healthcare, education, or living expenses, but they never actually own the assets inside of that trust. This is called beneficial use without ownership. So when you structure it like this and the trust owns those assets and your child is going through a divorce settlement, that settlement can only come after the assets that are in their personal name. And since the trust owns those assets and your child does not own them, that divorce settlement cannot go after those trust assets. So let's talk about how to set everything up so that your assets are protected from your child's ex-spouse. So the first step is starting with a revocable living trust. This is going to be the parent document. You will outline all the information related to your estate plan, things like what assets you're putting in there, who those assets should go to, and who's going to be in control of and benefit from those assets. And then the second step is going to be adding lifetime trust instructions. So in that document, what we would do is put instructions that state that when you pass away, that money or those assets are not going to be directly distributed out to your kids, giving them full ownership over it. What we're going to do instead is one of two things. We can either keep those assets inside of that revocable trust because it turns irrevocable when you pass away, or we can distribute those assets into irrevocable trust for your children. But in any route that we take, those assets are remaining inside of that trust, and we are not distributing those assets out to your kids. The third thing is who you choose as a trustee. So the mistake that most parents are going to make is that they will choose their kids as a trustee of their trust when they pass away. Now, the problem with that is that if your child controls the assets inside of that trust, the judge could argue that they constructively own those assets anyways because they have full control over those assets. You're going to need a neutral third party that can control the assets inside of that trust. It could be a family friend, another family member, or a professional like a trust attorney. The fourth one is going to be use fully discretional language inside of your trust document. Now, the language inside of that trust document has to be fully discretional, meaning you want to include language that does not require the trustee to give distributions out to your children. This means you do not want to require the trustee to give distributions out to your children, whether it's for healthcare, education, living expenses, or support. The reason being is that a good divorce attorney is going to be able to argue that that could be an enforceable right, and they could use those distributions for alimony or child support. You want to make sure that the trustee has full discretion on whether or not they do or do not pay, which is going to give a legal barrier for the assets inside of that trust. The fifth one is going to be naming remainder beneficiaries. So these are going to be the beneficiaries of the assets inside of your trust in the event that your child passes away. Typically, this is going to be your grandchildren going down the line of the child who's passed away. This will prevent a sideways inheritance where your child passes away, your spouse takes that inheritance, they remarry, and now a new separate family has full ownership over your assets. This is going to keep the money inside of your bloodline. Now, you've worked your entire life to build up these assets, to pass down to your kids, to take care of your family and make their lives better. One of the biggest threats that we face is that divorce rates are roughly 50%, and your child could go through a divorce even if they are in a happy marriage at the moment. Giving them a lump sum distribution of those assets can make it marital property and subject to being split in a divorce settlement. If you want help setting this up and giving your assets asset protection from your child's potential future divorces, click the link in the bio, fill out the form, and schedule a time to talk to some more of our team.